Good morning. Welcome, everyone. Please be seated. Okay, I recall when we left off yesterday, there was this issue about whether or not Captain Akey's comment about certain trainings occurring before the events of this case really took place, whether he was sure about that or uncertain or what have you. And I said, well, in the interview, he says he thought so, and that was enough to go forward unless the defense, specifically you, Mr. Conrad, I guess, had something more to add about it from some other materials. So did you find anything new?
Yes, Judge, I wanted to grab the actual exhibit so you could follow along.
I'm sorry, say again?
I wanted to grab the actual exhibit of the transcript so that you could follow along. So this is exhibit 746.
Right.
So there's two, this is an informal interview, obviously, with the Attorney General's office and the chief at the time, Akey.
Mm-hmm.
And so it's kind of this ongoing conversation, right? And so if you flip to page 23 initially, in the bottom of, it starts at the bottom of page 23 on line 25. Mr. Hillman is asking a question. He says, to your knowledge,
Wait a minute,
Judge?
and your knowledge is the very last line,
Yeah.
okay? And to your knowledge.
Knowledge, do your officers receive training on positional asphyxia, which is basically a form of asphyxia that occurs when someone is just the position that they're in prevents the person from breathing adequately. And Chief Akey responds, right, he says, from what I remember, we did have training on that conversation. I think that there was in-surface training. There was in-surface training. There was a video regarding something to that effect, but it may also have that connection to excited delirium training that we received. And that was, I think, Police 1, a series of training that we subscribed to. And then the conversation continues on, and if you go to page 45 and 46, Mr. Smith, Attorney Smith, 48, Judge, sorry, 48.
Okay,
And so you should probably actually start at the bottom of 47 where Chief Akey, so you can see Chief Akey's full answer, 47. Mr. Hillman's asking about, and I think you touched on this a little bit. You with me?
yes,
I think you touched on this a little bit. Your reaction as far as do's and don'ts. Do you remember training saying don't do certain things? No, I don't remember specifically because now let's say from what I'm reading my old notes, that's almost 6 years ago that training took place, and since that time things I know about excited delirium or things that people have told me, I'm afraid I'm going to mix in when I heard or when I learned of different things. But one thing I do remember is consider that is a medical condition. And then Mr. Smith interjects and he says, yeah, and I can add just via the magic of email I just received actually yesterday, none of the officers involved took that training. Right? And then leading in, I think, counsel, so to me when I'm reading that, it establishes the fact that this idea of positional asphyxia was taught within the excited delirium training of Police 1, and then Mr. Smith confirms that none of the officers involved had taken that training. So then we lead into, I think, page 76 and 77 is what the state wanted to get into.
that's right.
But if you look at page 75, in lines starting at line 14.
Let me get there. All right, 75.
75, starting at line 14, and I guess the question before that is, even before some of these new policies, was there a policy or practice or expectation about putting weight on someone who's in the prone position and restraint? Chief Akey responds, yeah, I have to tell you, a lot of this stuff that's just happening over this past year, I know that those discussions have taken place, John. I just don't remember where or how exactly, those conversations took place. Obviously, right now, after everything has happened, we realize it's a serious issue. Okay? And we talk about it in our training now and such. I just don't remember the timing of the conversations that happened before just the recent conversations. And then I just, go ahead, Kent, and then they keep going on into this conversation that council wants to get into. So not only has he indicated that the excited delirium training that teaches positional asphyxia wasn't given to these officers, which the in-service training, we're talking about in-service training, and that's why I didn't even get into this stuff. We were talking about policy with Mr. Ryan. But then these next couple questions go into what's his understanding of policy and training now. He's talking from a perspective of post-incident. And we brought 2 prior motions in limine. One was specifically tailored towards the fact that we said, it's almost under this idea of remedial measures, right? That you shouldn't talk about what's been done after the fact. It's what was taught at the time.
That's clear, and you don't have to talk about that again.
And this completely muddies the waters in terms of what was actually trained to these officers versus what was trained after the fact. And that's not fair. And I also brought another motion most recently while we were in court, which was to preclude the state. This is that motion in limine that I brought most recently, our third
Slow down a bit. Even I can't even hear what you're saying.
Sorry. This was our third supplemental motion in limine that I brought, and it specifically was tailored to former Tacoma Police Chief Don Ramsdell, former Tacoma Police Chief Akey, and former instructor Russ Hicks about, number 1, the dangers of handcuffing, hobbling, prone restraint, that they're dangerous. That was agreed to by the state, that we wouldn't go into that. And then the other motion limit was to preclude the state from calling Ramsdell or Akey or Russ Hicks to elicit evidence about trainings that were not provided to the defendants, including evidence of the training of a typical police department officer or CJTC training. Again, I believe that was agreed to by the state with regard to Akey and Ramsdell, but they wanted to bring in Hicks. And now they're just, again, I think they're trying to get into training that's post-incident. We've had these prior motions, and I think that they shouldn't be allowed to get into it. They can talk about policy, but they shouldn't be talking about specific trainings post-incident. Thank you.
Well, you don't want them to get into policies post-incident either, right?
Correct.
Okay. Go ahead, Mr.
Your Honor,
Club.
the state had no intention on going into the excited delirium positional asphyxia training that defense counsel Mr. Conrad just went through on page 24. We didn't ask any questions about that, nor did we intend to. I would note that there are some, it does muddy up the waters on when this occurred, but Mr. Conrad is the one that started asking questions from Chief Akey's transcript yesterday.
Well, sure.
But, in an abundance of caution with the concerns about whether or not this training was actually provided post-incident or before that, the state will move on to additional questioning. I think the...
So you withdraw the questions about pages 76 and 7.
Yeah, I'm not going to concede that that defense counsel is correct, and I will tell the court that there's no ill intention of the state to violate anything, and I think the court can see that based on the language that is throughout this interview and the conversations that occur in it. But we will withdraw the question and move on with that.
Okay. Is there anything else we need to take up before the jury comes out?
I would just note one issue. If defense raises anything and goes through that area, then and goes back to
If they dredge it back up, you'll keep dredging yourself. Okay.
potentially, we think it's worthwhile. Move the ball forward.
All right, fair enough. Okay. So, anything else we need to talk about before the jury comes out? All right, let's have the jury then. Thank you. Welcome back, Mr. Ryan.
Thank you.
You've been here long enough, we may need to charge you rent.
Yeah, that's right. Put my name on the witness stand or
That's
something.
right.
Nameplate.
Okay, resume when you're ready, Ms. Nicolava.
Morning, Mr. Ryan.
Good morning.
When did you complete your report? You have to see the exhibit?
I would have to see it, I'm sorry.
It's okay. Hand you what's been marked as State's Exhibit 490.
Signed February 24th of 2022.
And since you completed your report, have you received numerous joint interviews between defense and the state?
I had-
Officers that the interviews occurred after you completed your report,
Yes,
and you reviewed those interviews?
I have.
Mr. Fricky asked you yesterday about consensual contacts and the initial contact that occurred in this case. You recall him asking you that line of questioning?
I mean, it's been 3 days, so yeah, I remember being asked about it, but I don't remember if it was, when exactly it was.
Based on Defendant Collins' statement, he indicated that you called Mr. Ellis over to the car.
Yes,
Recall that? And based on generally acceptable police practices, is it standard, within those standards, to call a suspicious person over to the vehicle, patrol vehicle?
no, you wouldn't want to be a sitting duck in the vehicle, so you want to be out of the vehicle, so you have movement, so you're not stuck in the vehicle if the subject comes over.
What do you mean by sitting duck?
Well, it's dangerous. You know, I've seen in some training, they'll call the police car the rolling coffin, because if you can't get out, you're trapped. So again, you're just a sitting duck in the car.
And you were asked some questions about the 3 taser deployments, and I just want to ask a clarification question on the taser. When it runs for 5 seconds, is that the end of it, or is there an aftermath from it?
No, there's no aftermath. It's during that 5-second deployment. When you pull the trigger, it runs for 5 seconds unless you actually manually shut it off. At the end of the 5 seconds, the effect is over.
defense counsel, Mr. Conrad, asked you some questions about when Defendant Rankin removed the probes from Mr. Ellis, and based on his description of where the probes were located, would that allow for the NMI to occur?
Well, I think that would support that no NMI occurred because one of the probes didn't penetrate. Well, that would be consistent with what I see in the video.
And if a probe penetrates but doesn't penetrate like a surface penetration, how does that impact it?
Well, you won't necessarily get a complete connection.
And you said that was consistent with what you saw in the video. You were also asked a series of questions by Defense Counsel Fricke about the deployment of the taser and the justification for that. Based on the statements of both Defendant Burbank and Collins, during the deployment of the taser, did you see any strikes or punches from Mr. Ellis?
I don't.
You were asked several questions yesterday from Defense Counsel Conrad regarding, Mr. Conrad, I apologize, regarding the timing in which Defendant Rankin had Mr. Ellis in a prone position and was placing pressure on him. You recall that line of questioning?
I do.
I'm going to hand you what's been marked as State's Exhibit 65A, then for illustrative purposes, the interview of Defendant Rankin. And I'd ask you to take a look at page 31, line 17, through 32, line 1. During that interview, was Defendant Rankin asked about how long Mr. Ellis was on his stomach and hobbled?
Yes.
And what was Defendant Rankin's response?
He says he doesn't have any idea. It's hard to estimate. He's on his stomach hobbled. I couldn't tell you.
You testified earlier that you reviewed the statements from officers that were on scene. Did you also review TPD Sergeant Rock's interview from July 29th of 2021?
I did.
And that was an interview that was conducted by TPD.
Correct.
I'm going to hand you Exhibit 773.
I don't know. This was an interview with which one?
Sergeant Rock, Your Honor. It's an inquiry regarding the time in which Mr. Ellis was in the prone position.
No, well, then I'm going to have to be heard outside the president. Bring in Sergeant Rock next. Call Sergeant Rock.
Well, hold on a second. Let me see it.
Sure you have.
Thank you very much, Mr. Wright.
Oops.
Your Honor, page 8.
Okay. This gentleman, please excuse us while we have this conversation.
You want me to go out too, Your Honor?
No, I don't think you have to leave.
Your Honor, I would just note that defense counsel speaking of.
Please be seated, O'Brien.
Bring in Sergeant Rock and the comments with that followed the objection. I think it's inappropriate in front of the jury.
Well, anyway,
July 29th of 2021. So I referenced it as a TPD interview, not an IA interview.
How did you even reference it as that? I can just say interview. But more importantly to the point.
This is your confrontation clause issue.
It absolutely is. And what he says there is that he says, I'm guessing. I have no idea. And in fact, then the Attorney General's office did an interview with Sergeant Rock afterwards, and they asked him about the timing, and he said, it was a complete guess. I have no idea. He's like, I'm guessing. And so now they want to insinuate that it's 5 to 10 minutes when my client is even on scene for 10 minutes. And they're using an out-of-court statement, hearsay, for the truth of the matter asserted by a non-present witness against my client. It's the epitome of the confrontation clause in that regard. I never went into Sergeant Rock's statement on cross-examination.
Your Honor, I would note that the estimating time, that's certainly something that defense counsel can go through on cross. The confrontation clause, it was asked by multiple defense attorneys yesterday about, and they had 898 up. You reviewed all the interviews from those officers, those that were present at the scene, and they didn't intervene, and they're not here. And both Mr. Rosser and Mr. Fricky went through that with the witness. So the confrontation clause, and defense counsel Conrad went through multiple statements of individuals that were not witnesses, that were officers that were there. So, you know, nobody objected when defense did it from any of the teams.
That doesn't make it admissible.
It waives the objection.
As to each individual officer? Or it's not some blanket confrontation clause issue. It applies to each individual statement or each individual officer,
And
right?
if I recall the questioning correctly from defense counsel, they asked about each officer at the scene and went through each officer at the scene, including Sergeant Rock, as being a sergeant higher rank on the scene and not intervening.
Well, let me say, I'll stand corrected if that record shows otherwise, but I don't recall going through statements of the officers at the scene, and quite frankly, including my client's statement.
My recollection was Mr. Fricky referenced each of the officers at the scene and that those interviews and statements had been reviewed.
So Judge, here's Sergeant Rock from his interview with the state. Do you recall how long Manny was in the prone position? Answer, I don't know. I took a guess in my IA interview, and I really don't remember. Like I said in my interview, maybe 5 minutes, maybe 10 minutes, could be under that, but that's just a guess. That's what he told the state.
I also note that that was done in, I believe, 2023. In addition to that, I'd also note that that one line in the IA interview is the one line that was deleted and wasn't present in the transcript that the state received until we listened to the audio and found it in the audio and had it.
Who did you receive the transcript from, counsel? Don't imply that it came from us.
I didn't imply that.
Well, you didn't state that, so you did imply that.
Look, while you're reading, Your Honor, I shall be quiet.
Go ahead.
You know,
I can ignore you whether I'm looking at you or reading my, just equally well.
You know, it's, when you reference and say, yes, you interviewed whoever, or you looked at this particular document, and you don't go into the substance of the document, you don't open it up to let hearsay come in. It's like you talk to any investigating officer or an expert or whatever, so long as you don't get into the substance, that doesn't waive any hearsay objection.
Okay. When Mr. Ryan was being cross-examined by Mr. Rosser, there was an issue with respect to the materials that had been reviewed by Mr. Ryan. There were some in which some specifics were given with respect to Trooper Jones, for instance. But collectively, the issue was that other officers do not mention Rankine-Sino and Ellis as he was fighting for breath. And Mr. Ryan saying if they saw it, they should have intervened. Now, I'm not sure I wrote this down, but I think he may have said that, and they should have reported that. But that was sort of a collective. That's really kind of the most I've got with respect to this. And it kind of came back again, that same issue. When it was asked who he was asked to evaluate, like when there was an issue about whether or not he was asked to evaluate Officer Ford's conduct, for instance. But, so, the issue is the specific comments of Sergeant LaRock at this point. And yeah, I'll grant the objection that it's hearsay. So, we ready to have the jury back?
Your Honor, can I have one moment to do a search on, not going to the court to ask you to reconsider, so I am certain that this isn't going to be another issue for another question.
Sure.
Your Honor, one of the questions I do have with that is, experts can rely on the hearsay, so,
I understand that, but you're really not asking him about that, because his opinion has to do with what police procedure ought to be, not, in this case, how long which is essentially that as soon as absolutely possible, you should be moving a person from a prone position to a sitting position or to a rolled over position on their side. How much time took place in this particular case is a factual matter, not really a matter of opinion,
right, so
right? So it doesn't affect his opinion at all.
the amount of time on how long it took place in this case has been an issue and dispute throughout the entire
Right,
testimony.
but it's not a matter of his opinion. Right. His opinion is, well, I guess I would say his opinion seems to be that at any time you can, you should be having this person not on the prone position. There seems to be some information in the Tacoma police procedures which suggests you can have the person in the prone position until you have them under control, which may be a bit different, but regardless, once they're under control, they should have taken them, his opinion is clear, they should no longer be in the prone position. It doesn't matter how long it is, he shouldn't have done it, right? And then it's a matter of a medical opinion as to whether or not Mr. Ellis's position in a placement in a prone position for however long it was, which is up to them to figure out, based on all the information we've got, contributed to Mr. Ellis's death or not.
Could I inquire of the witness?
I can't imagine what it would be.
I just want to ask if the 5 to 10 minutes from Sergeant Rock played any part in his testimony regarding his
It
opinions,
wouldn't-
or in his opinions that he's provided.
I can't imagine what it would be. And if he said yes, I would discount it, for the simple reason that his opinion is, it's certainly as clear as this, but maybe even more, even less clear, is what I've just stated. Once the subject's under control, he should be on his side or sitting up, but certainly not prone. And it doesn't matter how long it is, he shouldn't be doing it that way. Right? Is that true?
Yes, Your Honor.
So why does the time matter? It only matters because it's potentially the medical causation, which is beyond Mr. Ryan's expertise to opine on. So,
Okay, Your Honor.
I
Agree to
mean,
disagree, and I'll move on.
well, I mean, your principle is right. If in the sense that it is possible that an expert opinion can be based upon what otherwise would be regarded as hearsay if it's the kind of thing that's customarily relied upon by experts in the field and so on. But in this case, the opinion about how long it is doesn't matter about, well, whether the use of force was proper or not. If it occurred at all, even if it's for 30 seconds longer than it needed to be, it's a violation of police procedure, right?
Yes, Your Honor.
So the duration isn't a part of it. So, anything else before we get the jury back?
One second. Your Honor, just one last bit on making a record for it. The court has allowed him to go into, defense to go into specific facts and statements, and I recognize the court has said not of Sergeant Rock, but the state is in a position of not being able to present contradictory statements and evidence in the same manner in which the defense has been able to do so, and ultimately using it as both the sword and the shield, and the state was in a position of, okay, and we've got to,
Well, you can call Sergeant Rock and ask him, right?
right, and I'm saying the court isn't allowing the state to do it in the same manner in which the court allows defense to do it. But
Well, that's a criticism of my ruling, but then that's fine, you've made it.
thank you. We're ready for the jury.
Okay, let's have the jury. Okay, welcome back, everybody. Please be seated. Okay, objection sustained. Next question.
Mr. Ryan, you were asked yesterday specifically about Trooper Casey Jones' statement. Do you recall that?
Yes, I was.
And Henny, what's been marked as States Exhibit 822, his initial report. And this, based on, and you reviewed that in your review and analysis of the case.
I did.
And what time did he arrive on scene?
It says 23:27, which would be 11:27 at night.
And what position did he note Mr. Allison being?
He noted him to be in a prone position on his stomach. I'll have to find exactly where it is. I remember being questioned about it yesterday. Yeah, I observed a male lying on his stomach detained in handcuffs. He was screaming and appeared to be striking the pavement with his head.
Henny, what's been marked as States Exhibit 824, the joint interview of Trooper Jones? And did you also review that?
I did.
And on page 30, does he note the position, page 30, lines 12 through 22, does he note the position of Mr. Ellis when he was on scene?
I'm sorry, the line?
12 through 22.
What's the exhibit number again?
It is 824, Your Honor.
Thank you so much.
Excuse me, I apologize, 29. In reviewing that, what position does Trooper Jones indicate Mr. Ellis was the entire time that he was on scene?
He says that even when he left, that
Sorry, I can't hear you.
He can refresh his recollection with it, but he shouldn't.
I can rephrase it, Your Honor. That's fine.
Please do so.
Mr. Ryan, after reviewing the interview of Trooper Casey Jones, do you recall the position that Trooper Casey Jones saw Mr. Ellis in the entire time that he was on scene?
I understand what you're saying. I'm going to permit the question.
he said he was in the same position, the prone position, when he left the scene.
And when you go back to his report, the other exhibit in front of you, which was 822, what time does he indicate that he left the scene?
23:33, which would be 11:33.
In reviewing the collective, the reports as a whole from the different officers, do you recall being asked by Mr. Fricky yesterday about where Officer Burbank and Collins, he said they were removed from the scene? Do you recall that line of questioning?
I do.
And in reviewing the reports, did you find information that could clarify the remove from the scene?
Yeah, they were not with Mr. Ellis, but they had moved to the front of their car, I think one officer says, or maybe two officers say. So it's moving a short distance away, but it's not, they didn't clear the scene, so to speak.
So, but in front of the patrol car.
Their patrol car, yes.
And you were asked a couple questions by Mr. Conrad about mic clicks and the stress that that could cause for an officer that's responding to the scene. Do you recall that line of questioning?
Yes.
And if an officer is stressed or a heightened level of anxiety from hearing those mic clicks, does that change the analysis at all on whether or not the force was proportionate?
No, the officer still has to, use proportional and reasonable force.
seriousness of the offense?
The, what an officer should do, as I understand the witnesses, based upon what they are experiencing. And as I understood the issue about the mic clicks was, Officer Rankine came into a situation that had already occurred, and this was the limited, this was among the bits of information he had. I don't know that it changes the standard, but what one person would do is based upon their perception, and their perceptions may be different from the next person, even at the same location. So I'll permit the question.
Does the answer stand then, Your Honor?
Answer stands.
You were also asked some questions by Mr. Conrad about Defendant Rankin being on the force for just over a year. I think it was 14 months or so.
Yeah, I think when we did the math, it seemed to be about 14 months.
And does the proportionality of force standard and analysis change when an officer is on the force for only 14 months?
No, it still has to be reasonable and necessary, and it has to meet the proportionality requirements of what they're facing from the suspect.
Your Honor, the state has no further questions. See if I can just have a minute to get this.
Sure. Okay, Mr. Fricke, recross.
Just have a few follow-up, Your Honor. Good morning again, Mr. Ryan.
Good morning.
Hope you're enjoying your stay. On that one of the last questions about Mr. Burbank and Mr. Collins not being on the scene, they're not hands-on at that point, correct?
That's correct.
And they're by their car, and that's where Lim, I don't know if he directed them to go there, but had engaged him in a conversation while things were still going on. Fair to say?
I think that's fair to say.
And so also fair to say with that conversation, they're no longer involved after that point in time with preventing Mr. Ellis from moving in any way, correct?
They're not hands-on at all, no.
Okay. Now, you, yesterday on, I can't remember if it was on direct, or excuse me, redirect or cross by one of the other gentlemen here, but you mentioned that when Mr. Rankin had turned over Mr. Ellis into a recovery position, one of the things he did was look to see if there was any weapons or that type of thing,
Correct.
which is when he found, as it turns out, my client's gun magazine, correct?
There's a gun magazine on the ground or something right there, yes.
And you characterized it as dropping out of his vest, if I remember correctly.
Well, it came out of his vest somehow.
Right.
By his, we're talking about
Officer Burbank.
not Mr. Ellis.
No.
Officer Burbank.
Right.
Thank you, Ryan.
Okay.
It came out somehow.
Correct.
Whether it was Mr. Ellis reaching in and getting it out during the struggle or falling out on its own, we have no idea. Fair to say?
I would agree with that.
Okay. Now, you mentioned here just a bit ago that when Officer Collins called Mr. Ellis to the car, that was not basically a wise thing to do.
Tactically, it's unsafe.
Yes, you mentioned a sitting duck in the car. Mentioned that sometimes officers refer to cars as a coffin,
Rolling coffin, yeah.
a rolling coffin. And it has nothing to do with the use of force in this case.
Well, it could. If an officer puts themselves in a bad tactical decision, they may have to use more force because of that.
Right. But that didn't happen at that moment.
Correct.
And so, in general, that might be the case. But that didn't happen here.
That didn't lead to any force on Collins by Manny Ellis at the door, no.
Okay. And not smart because, like you say, when you're in your car, you're sitting in a seated position, and the person who's walking around there you don't know about, they could pull out a gun and blow you away, basically.
They could do that, or they could do anything, any other kind of act of violence, particularly when you,
So, it was certainly within.
Let him
police-
finish his answer.
Oh, I'm sorry, I thought you had.
particularly when you have a suspicion that they were just trying to pull open a car, if that happened, if you believe that version of events.
Yeah. And certainly it was within police practices, when they did get out of the car, that was what they should have done eventually, right?
Well, under their version of events, of course.
Or under any version of events, if they just called him over to talk to him, they should have gone out. They shouldn't have him come to the car. They should have got out and talked to him.
Absolutely, if they were going to talk to him, if that happened that way, yes.
All right. Now, you mentioned yesterday when you were going on, I think it was Mr. Conrad was asking you about situations where a person's in handcuffs, they get out, in one instance you recall an officer was killed.
Yes.
And I assume you teach that to the people you teach in the organizations, is that right?
Well, I certainly teach that a person, particularly if they haven't been searched yet, the case I was talking about, the guy was able to pull out a gun, notwithstanding the fact that he was handcuffed, and shoot the officer. So, obviously, until you get them, secured, searched, they can be dangerous.
Right, and secured, and we're talking totally secured, fair to say.
Well, we're talking secured in handcuffs, and then the next step should be to search them. Unfortunately, that officer in that case made a tactical mistake because he didn't search them right away.
And it cost him his life.
They sure did.
And obviously, that's a concern of any officer on the scene who's in a situation like this. That if they make a mistake, it could cost them their life.
Well, a tactical error can make the situation worse, of course.
So you can't just rely on that, you got the handcuffs on, does not necessarily mean the suspect is secure, fair to say?
No, I think it means his hands are secure, and then you move on to the next steps. It certainly dissipates the threat, as we talked about yesterday.
And do you train people in your experience that sometimes it's suspects who are cuffed can break out of those cuffs? Have you seen that happen?
I've seen people able to get out of cuffs. They got small wrists, double jointed or something. I've seen scenarios like that. It's never happened to me. I don't know if it's ever happened to anybody in any of the cases that I've been involved in.
And you, again, always couches the use of force being reasonable.
Has to be reasonable and necessary.
And that's obviously dependent on any given situation, as we discussed in the Graham case.
Of course.
Okay. Do you recall when we had our interview, which was on Zoom, if I recall correctly?
Yes, it was.
It's always make it a little bit difficult. But at any rate, I was trying to ask you questions and find out exactly what you were saying as far as your criticism in this case. And that's just a general term. But do you recall me asking you, so based on your review of materials, whatever you reviewed, you're saying you saw nothing that would have allowed these officers to use the degree of force they used, and your response being, I'm saying that certainly at the end, the restraint process, the pressure on the back, absolutely, and left in prone position, absolutely. And then I followed up, if you recall, and I said, when you say the end, what are you referring to, just so I know? And your response is, so when the officers get him finally restrained and in a hogtie, then the immediate action should have been to get him in a recovery position. And then that all officers involved in that hogtie and restraint process had that responsibility. Do you recall that conversation?
In relation to the end being there's no, it doesn't matter whose version of events it is.
Okay.
The obligation is. On the first uses of force, it's going to depend on whose version of events the jury adopts.
All right. And would you finally, just a couple more questions, as far as Graham goes, would you agree that the more serious an offense is, the more force an officer may use?
Of course.
Would you agree that the more of a physical threat the perpetrator poses, the more force an officer may use?
Absolutely.
Would you also agree that the more a perpetrator actively resists or attempts to evade arrest by flight, the more force an officer may use?
Depending on the seriousness of offense, absolutely.
And those are quotes from your article that you had in the, I think it's the Toro Law Review, back in 2008?
Toro Law Review, I wrote that with Karen Blum, yes.
With Karen Blum, correct. And those are quotes, right, from you?
Correct.
And you indicated, if a person doesn't comply, a lot of people think a person always complies, I think as you allude to it here, but what you see in many of cases that you see and teach is an officer approaches someone, the person decides not to comply, and so the officer is forced to respond to the subject's resistance.
Absolutely.
That's all I have, Your Honor.
Touro, I think.
I'm sorry.
She was asking for spelling.
Oh, okay.
Mr. Usher.
I don't have anything to
Sharon, do you still have, what exhibits do you have?
I have a whole bunch. So if you might want to just ask me, give me a number and I'll see if I have it.
Okay. Give me one second.
Or I can tell you, I have 822, I have 824, 773, 490,
Here, let me help you out.
and 65A.
Okay. So you're just asked on direct examination about Trooper Jones, remember that?
Yes,
Counsel was asking about the time period that he was there and the prone positioning.
correct.
Right? And so Ms. Nicolavo handed you exhibit A22, right?
Yes,
And I'll hand you that as well, with Trooper Jones, his statement, that's his initial report, right?
yes,
Where he indicates that he sees Ellis in the prone position and banging his head on the ground, right?
When he arrives, yes.
Okay. And then counsel then asked you about his interview, where he indicated that he saw Mr. Ellis in the prone position during the period of time that he was there, right?
Well, he said that he stayed in the same position, I think is what he said.
Okay. And then counsel asked you to indicate what the time period was that Trooper Jones was there when he indicated that he had left.
Correct.
And that was pursuant to the CAD report, right?
No, that's
Pursuant to his report.
pursuant to his report.
But do you remember in his statement that he's writing that pursuant to the CAD report?
You'd have to show me that,
Okay.
but that may be the case.
Okay. So, and Trooper Jones doesn't say in there that when he's there that there's anyone on top of him or anything like that, right?
Not in this report, no.
Okay. And so I'm going to hand you 824, which is the interview of Trooper Jones by the Attorney General's office. And if you turn to the second page, it indicates who's present, right?
Mr. Thomas, ask that you make sure you're direct with the monitors present.
Sure. So it indicates Ms. Nicolavo's present, right?
Yes,
Ms. Eakes is present, I believe.
yes.
Okay. And if you turn to page 35, line 22. Let me know when there.
Yes,
Okay. And the question is, so the call details has you clearing at 23, 33, 34, right?
correct.
And that's this,
This is proper impeachment if you,
Let's do the rest of the question.
okay. So they're questioning him about the time that he cleared the call, right?
Yes.
Okay. And that, the time period that they have there, that's pursuant to the call details, and it says 23, 33, 34, right?
Correct.
Right, and that's the same time period that's on his, indicated on his report as well, I believe.
Well, on his report, it just says 23:33. It doesn't have the seconds.
Okay, down to the seconds, not down to the seconds in his report.
Correct.
And then the Attorney General's office asked about the time period in which he's there and the procedure for when he clears the call, when he indicates at 23:33 when he's cleared from the call. Do you see that? On to the next page.
Yes.
And they specifically asked him, so the time entry that's there, do you do that at the time that you're actually leaving the call? Or have you already left the call and you've done something else and you indicate that time afterwards? You see that?
Yes.
Questions? And he said, he indicates to the Attorney General's office, no, that time period, 23:33, 34, I entered that afterwards.
He does say that. Yes.
He does say that. And he says, in fact, I'm off scene already at 23:33. I'm either checking on my dog or doing something else or getting my stuff gathered together, and that's when I enter that time. That's what he indicates, right?
He does. He says he's checking on, he may have been checking on his dog or grabbing a water or doing whatever.
And so that time period that he's there, that's not that the time that's entered there, 23:33. That's not the actual time that he leaves the scene, right?
Not according to that statement there.
Okay. And in fact, he says that he believes that he's there. Well, let's move on. So the implication that he's in the prone position from the time of his arrival to that timestamp of 23:33, as if he's on scene the whole time that he's there, that is not correct, right?
On the timestamps, but he also talks in the statement about how long he believes he was on the scene.
Correct, and he says 3 minutes.
3 to 4 minutes.
3 to 4 minutes.
Correct.
Okay, but 6 minutes, that's not accurate.
Not according to what he said there.
Okay, so the implication that he's there for 6 minutes because that's the timestamp that was there, that is not what he said in his interview.
When you do that follow-up, correct.
Right, and the state was there for that interview, right?
Well, there was a lot of people there for that interview.
Okay, well, the state was there for that interview, right?
Correct.
Okay. One last line of questioning I have for you is the proportionality, right? And the reasonableness standard under which the Graham case is decided. That, the reasonable officer standard says you take into account the training and experience of that individual officer as well, right?
Absolutely, the officer's training and experience can be added to the analysis, yes.
Okay. And in this circumstance where you have, obviously, I don't want to go through all of it again, but when you have a situation where Officer Rankin is on scene and he's in this initial contact before other officers arrive, is it your testimony that when Mr. Ellis is trying to get his legs underneath him and get up, that it would be improper for Mr. Officer Rankin to hold Mr. Ellis down at that point?
On his stomach, absolutely.
Okay. So, ensuring that the suspect, who Officer Rankin reasonably believes is armed and has attacked officers, ensuring that he stays on the ground and does not get to his
Judging
feet.
on to the form of the question, there's no evidence that he reasonably believes.
Sustained. Try again.
Okay. So we've established that there's a gun magazine there, right?
At some point, they saw a gun magazine, yes.
That's right. When Officer Rankin initially comes on scene,
At some point, they do. I'd have to see the timing.
he has no idea whose it is.
I think they knew it was a Glock magazine, but I don't know that anybody says they knew exactly who it belonged to.
We've established that when Officer Rankin arrives on scene, he sees two of his fellow officers, highly trained and experienced officers, struggling with this individual, right?
Absolutely.
And this individual was trying to get up off the ground at that point in time.
Your Honor, this is outside the scope of redirect.
Rule, you may continue.
That's what he reports, yes.
Okay, he knows that these officers have also not been responding to calls for updates, right?
I think that's accurate.
That they've only screamed out their location,
They certainly yelled out their location.
and this individual is now trying to get to their feet, right?
He may say that, I'm not sure.
Okay. And we now know this individual has a large amount of methamphetamine in their system, right?
That's 20/20 hindsight, he didn't know that at the
Okay.
time.
We now know that.
We know that he had methamphetamine in his system, yes.
We also know that he was on pretrial release at the time of
Objection,
this.
Your Honor.
This was testimony from Brockway.
Actually,
Well, here's the deal. Whether that's true or not, that wouldn't bear on Mr. Ryan's opinion about the officer's conduct when it wasn't known to the officer at the time. And there's nothing that indicates that Officer Rankine had that information,
True.
although Mr. Ellis may have had that information.
That's more my point.
Well, you can certainly ask him, I suppose, about any aspect about Mr. Ellis's behaviors as that would have been seen by the officer.
Okay.
Your Honor, I object because it's still not in evidence. Lieutenant Brockway didn't testify to that. This counsel-
But it isn't necessarily just Lieutenant Brockway. This information may be available elsewhere.
Is this a matter of in dispute? Because,
You've got the ruling.
okay.
Proceed.
So I don't know if you're aware, but are you aware that in terms of Mr. Ellis's motivations at that point, that he was not supposed to be using methamphetamine? You aware of that?
That may be in the material somewhere. I know that, I think that was mentioned somewhere in the materials.
Okay. And are you aware that that's pursuant to a court order?
I don't recall that, but it may be.
Okay. I don't have any other questions.
Any further direct?
I have a few questions.
Go ahead.
What exhibits do you have in front of you, Mr. Ryan?
I do.
What numbers, please?
I have 824 and 822.
I'm gonna actually start with State's Exhibit 65A regarding Lieutenant Rankin's statement. You were asked by Mr. Conrad and I think Mr. Fricky about this magazine that was found.
Yes,
Do you recall that line of questioning?
yes.
And if you turn to page 11 of Mr. Rankin's interview, what was the status, turn to page 11 and line 9 down, what was the status of Mr. Ellis at the time when the magazine was located?
And did you say line 9?
Starting on line 9 to 15, and then actually go ahead and go all the way to the bottom of the page.
Okay, I've read it.
And after reading that, does that refresh your recollection on whether or not Mr. Ellis was handcuffed?
He was handcuffed. There was also officers holding his legs.
And who actually found the magazine?
Officer Ford asked whose magazine it was.
And where was it actually found at?
It sounds like it was on Manny Ellis's back.
And that was before the hobbles were placed.
Yes,
And then you have State's Exhibit 822 in front of you, Casey Jones' report.
yes,
And you were asked several questions about the timing in which he left the scene.
yes.
And he indicates, as you testified, he indicates in his report and in his interview that he put in 2333. And where did this incident occur at?
96 in Ainsworth?
Right, so, where was he at, when he was leaving the scene? What street did he turn onto? The bottom of his report?
He said as I turned southbound on Ainsworth, I observed medical aid, so he turned onto Ainsworth.
And he observes medical aid arriving on the scene
Ye-
when he is leaving the scene?
Yes.
Thank you.
Good question, John.
Brent?
When Officer Ford, when he found located the magazine, the gun magazine on Mr. Ellis, he indicates as well that he asked out loud, right, whose magazine it was.
Correct.
Okay. And that there was no answer given at that point, right?
That may be in Ford's. I don't think that's in, I'd have to go back and look at the one I was just looking at, Officer. I'd have to see Ford's. He may say that.
Okay. I don't.
Nothing further from the state.
Okay. Thank you, Mr. Ryan. You are excused.
Thank you, Your Honor.
Okay.
Yeah, just switch seats.
Sure. Do you need a brief recess just for this, or?
No, Your Honor.
Okay.
We're ready to call it next.
Okay, great. Whenever you're ready then.
State Boss Teresa Charonka.
Okay, yes, ma'am. Please come forward to right about here if you would. Okay, so right about here, then please raise your right hand to be sworn. Do solemnly swear or affirm that your testimony in this cause will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you very much, ma'am. Have a seat right here. Please state your name and please spell your name.
Good morning. My name is Teresa, Teresa, Charumka, Cheromcha.
Okay, Mr. Liu?
Thank you, Your Honor. Good morning, Mr. Charonka. What is your occupation?
Good morning. I am a senior DNA analyst, and I work for DNA Labs International, located in Deerfield Beach, Florida. It's a private forensic laboratory.
And how long have you worked for, can I call it DLI for short? Is that-
Yes, thank you. The abbreviation for DNA Labs International is DLI, and I have worked there for a little over 2 years now.
And what do you do for DLI?
I am a senior DNA analyst, which means that my primary duty is to author reports and then testify in court as needed. This entails reviewing any and all documentation and testing activities that may have been performed in a case to ensure that they align with the submission details along with our standard operating procedures. I analyze and interpret DNA profiles and make conclusions that are summarized in my report.
And Ms. Charonka, what did you do before you worked for DLI?
The 10 and a half years prior to DLI, I worked as a forensic serologist and DNA analyst for the Colorado Bureau of Investigation, located in Grand Junction, Colorado. The last 4 years of that, I was the assistant DNA technical leader. So basically, I performed forensic serology and DNA, and then in my capacity as a assistant technical leader, I assisted in training new analysts, updating standard operating procedures or manuals, and performing validations on new methods that may be applied to casework and determine their suitability.
Excuse me, Officer Burbank is going to stipulate that the work that you did resulted in DNA which related to Mr. Ellis. We have no objection to that.
We stipulate as well.
Well, that's fine. Both sides have to accept the stipulation. As I understand it, there may be some concern by some parties in this case, so thank you, but nonetheless, we're going to proceed. Mr. Liu.
Ms. Stronka, can you describe for us your education and training?
Certainly. I received a bachelor's degree in biology and a bachelor's of science degree in biology and biotechnology with a concentration in cellular molecular biology and genetics from the Worcester Polytechnic Institute. I then received my master's of forensic science degree with a minor in forensic molecular biology from the George Washington University. The second question was regarding to training. Whenever an analyst goes to a new laboratory or system, they need to go through a very rigorous training program that is documented and monitored. So this includes scientific readings, and also the standard operating procedures for the new laboratory that you are at, observations of current analysts and demonstrations. So in this case for me, it was primarily remote because I don't work in Florida. I also had to perform interpretation exercises to demonstrate that I could follow DLI's standard operating procedures and come up with conclusions that were comporting with the manuals that we have to follow and the guidelines.
Thank you. Have you testified as an expert in court before?
Yes, I have about a dozen times in Colorado District Court.
And Ms. Stronka, how long have you been performing DNA analysis?
In total, I've been performing DNA analysis for about, human-specific DNA analysis for about 16 and a half years. Prior to my job in Colorado, I worked for the Armed Forces DNA Identification Laboratory, located at the time in Rockville, Maryland.
And to educate the jury, what is DNA?
DNA stands for deoxyribonucleic acid, and it's the genetic blueprint for all living things. Most of humans' DNA is the same between individuals. That's why we tend to have 2 arms, 2 legs, 1 nose. But there are particular regions on the DNA that may be unique to an individual, especially when you look at multiple locations. So, pardon me, forensic DNA analysis is the process by which I'm looking at particular locations in the DNA of a sample or a reference sample and evaluating the data that I receive from that. If you think of your DNA like a 23-volume encyclopedia for each of your chromosome pairs, basically I'm targeting 23 pages in that entire encyclopedia, not all the volume. That's too much information, and much of it is not forensically relevant because it could code for medical information or your physical appearance, and that's not what forensic DNA analysis is examining or targeting in this case.
And how might a person's DNA get on an object?
There are a couple different mechanisms or ways in which an individual can get DNA on an item. The first one is direct or primary contact. So if you think about if it's a beautiful day outside in the park and you sit down on a bench, but it has wet paint, you've transferred paint onto you. That is a direct contact that you made to that bench. So it's direct contact or primary transfer. Now say that you don't realize this, you go home, you sit in your favorite chair. Now some amount of paint has transferred from you to your chair. The chair was never in the park or near it, but nevertheless, some of that material has transferred from the bench to you and you to the chair. That is an example of secondary transfer. And this all depends, how much of that paint was wet. Was it a lot of paint or just a little bit of paint? These are kind of the same principles in relation to trace DNA, where we don't necessarily know if there is a body fluid or not, or if it's skin cells, and we don't know if it's direct or indirect contact that has resulted in that information.
Ms. Stronka, is it possible to compare DNA from a known donor with DNA from, say, a crime scene?
Yes, that is a common comparison in forensic DNA analysis.
explain or describe for us the steps involved in DNA analysis?
There are 4 general steps in the laboratory for DNA analysis. The first is the extraction of your sample. We are adding chemicals to a swab or a cutting in a little tube in order to isolate and purify the DNA. The second step is called quantitation. We are determining the estimate amount of DNA, human DNA, within a sample. This second step helps us with our third step, which is called amplification, or polymerase chain reaction, PCR. This is basically a molecular Xeroxer. So this is where I'm targeting those particular pages in your encyclopedia. I'm not changing what's there, I'm just making more copies of those pages of interest. I do this I don't do this directly anymore, but it is performed on the evidentiary sample and the reference sample. So that way the same locations are targeted in order to examine them. Once I have my amplified product, I need a way to visualize it. The fourth step is when that amplified DNA sample goes onto an instrument called a genetic analyzer. Once the data comes off, I review it in a software program and begin to examine it for interpretation purposes, assigning the number of contributors that could be in a sample. And I make all these determinations and estimations prior to examining any references that are submitted with the case. I try to do things in a linear manner.
Ms. Taranka, is this, the technology that you use, is this generally accepted in the scientific community?
Yes, that kind of 4-step procedure has been how it's been done for, I would say, over 25 years or so now within the industry. And of course, things do change. New instruments come out, new chemistries for that amplification target. You know, we used to target, 8 pages in the book. Now we're targeting 23, 27. So our technology is growing, but the same basic steps have been the same.
Ms. Taranka, did DLI receive physical evidence regarding this case?
Yes, it did.
And what did DLI receive?
Excuse me, DLI received in this case 1 item of evidence, a hobble strap, and then 1 reference standard from Mr. Manuel Ellis.
When did DLI receive the hobble?
Your Honor, may I refer to my report?
Ms. Taranka, did you prepare a report regarding your findings and analysis?
Yes, I did.
If I may approach, Your Honor. Showing you what's been marked as State's Exhibit 26. I'll ask that you take
Thank
a look
you.
at that, see if you recognize what that is.
Yes, thank you. I do recognize State's Exhibit 26.
And what is Exhibit 26?
It is the certificate of analysis, which is the fancy word for my report.
After referring to reviewing 26, do you recall when DLI received the hobble?
Yes, evidence was received in this case on August 3rd of 2023.
And what were you asked to do with it?
DLI was asked to examine the hobble strap and take up to 2 collections from that item for DNA analysis.
Ms. Taranka, you referred to a reference sample. Can you tell us what that is?
Yes, a reference sample is a sample taken directly from a known individual. And that's why it's called a reference, because we know that it came directly from a person who either reported who they were or we know from other means. So it's a direct reference for a person.
And did you receive a reference sample related to someone named Manuel Ellis?
We did. We received what's called a bloodstain card from Mr. Ellis.
And what is a bloodstain card?
A bloodstain card is maybe a little bit smaller than an index card, and it has some nickel-sized areas where liquid blood can be dropped. And then it's a specialized paper, so it preserves the DNA sample at room temperature for future use.
And Ms. Taranka, was a DNA profile developed from the reference sample?
Yes, a DNA profile suitable for comparison purposes was developed from the reference standard from Mr. Ellis.
And Mr. Franca, I'm going to hand you what's been previously admitted as State's Exhibit 100. And there's some gloves there for you.
Thank you.
I'm going to ask that you take a look at the exhibit and see if you recognize what that exhibit is.
So I see that there is DNA Labs International, or DLI, evidence tape, and I recognize the initials and date on it from August 3rd, and this is identified as the hobble strap that was submitted and has the same property number as referenced in my report.
Thank you. And if you could go ahead and take a look at the item contained inside. And Ms. Franca, do you recognize that exhibit?
Yes, I do. The serologist in this case took a picture of this item, and so it is consistent with the picture that I have stored electronically, as well as the same property evidence tag number.
And what is that tag number?
It is CY6270.
And did you also note that in your report?
Yes, the agency item number is noted on my report.
And did DLI obtain samples from the strap?
Yes, DLI collected 2 samples from the strap. One was from most of the strap to include the metal buckle, and then the second sample focused on the carabiner or clip end and the material right around it.
And Ms. Franca, did you analyze the samples from the strap?
Yes, I analyzed the DNA profiles developed.
Using what method?
This was performed using the method that I explained to you earlier, that 4-step process.
Ms. Franca, was a DNA profile developed from the sample from the loop and buckle of item Exhibit 100?
Yes, Your Honor, may I read from my report for accuracy?
Any objection? Proceed.
Thank you. The DNA profile obtained from the interior loop and metal buckle indicates a mixture of at least 4 individuals with at least 2 male contributors. Manuel Ellis could not be ruled out as a possible contributor to this mixed DNA profile. The DNA profile obtained from this sample is approximately 19 billion times more probable if the sample originated from Manuel Ellis and 3 unknown persons than if it originated from 4 unknown persons. This analysis provides very strong support for the proposition that Manuel Ellis is a contributor to the DNA profile obtained from the sample. The DNA profiles of additional contributors to the mixture were not determined. However, the results are suitable for comparison.
Ms. Franca, what does very strong support mean?
The number that I gave to you is a statistic called a likelihood ratio. That number can range from 0 to infinity. And so it's hard for a layperson to understand what that numerical value may mean and give it appropriate context. The Scientific Working Group on DNA Analysis Methods provided a recommended verbal scale, and that's what I am using today in this report. So it allows the numbers that you might obtain from a likelihood ratio to be binned, if you will, and given a verbal qualifier. So it goes from exclusion, uninformative, limited, moderate, strong, and then very strong. Likelihood ratio values of 1 million or greater are considered very strong support for the proposition.
Ms. Franca, is this calculation method generally accepted in the scientific community?
Yes, it is.
Was a DNA profile obtained from the clip and material around the clip?
Yes, Your Honor, may I once again read from my report for accuracy?
No objection.
Proceed.
Thank you. The DNA profile obtained from the clip end and material around the clip indicates a mixture of at least 3 individuals with at least 1 male contributor. Manuel Ellis could not be ruled out as a possible contributor to this mixed DNA profile. The DNA profile obtained from this sample is approximately 1.8 million times more probable if the sample originated from Manuel Ellis and 2 unknown persons than if it originated from 3 unknown persons. This analysis provides very strong support for the proposition that Manuel Ellis is a contributor to the DNA profile obtained from the sample. If applicable to the case, it is recommended that reference standards for many first-degree relatives of Mr. Ellis be submitted for additional comparisons. The DNA profiles of contributors to the mixture were not determined. However, the results are suitable for comparison.
Ms. Ronka, based on your analysis of Exhibit 100, the hobble strap, and the reference sample, can you conclude that Manuel Ellis's DNA profile was on the hobble?
That's not something I can conclusively state scientifically. I can merely say that with the statistical analysis that was performed, the evidence provides very strong support for the proposition that Mr. Ellis is a contributor to each of those profiles.
Okay. No further, I've got one more.
Sure.
No further questions for Ms. Ronka. Thank you.
Yeah, thank you. No question.
Your Honor, thank you. Just one or two questions.
Go ahead.
Good morning. You're aware that my client, Officer Collins, gave the state patrol that hobble, correct?
I am not aware, actually.
You're not aware that he said this is the hobble we used that night on Mr. Ellis?
Your Honor, the witness has always indicated that she is not aware.
I'll permit the question.
From the submission information, I did not know who had the hobble, no.
Okay. Where are you from?
I reside in Grand Junction, Colorado.
Okay. Did the state pay to fly you here?
I don't know that information. I'm certainly been provided travel, but I'm paid the same whether I'm at home doing my work or here testifying.
But you work for a private company, correct?
I do, yes.
And are you aware of whether the state has paid your private company for your analysis and for you to fly here and testify in this case?
I believe that they probably have.
Do you know how much?
I do not.
Thank you.
I don't have any questions now.
Thank you, Your Honor.
Okay. You are excused. Thank you very much.
Thank you, Your Honor.
Have a safe trip home.
Thank you.
Okay. State's next witness.
Your Honor, we'll take this recess that we discussed yesterday.
Okay, we're close to our morning recess anyway, so we'll go ahead and do that. Ladies and gentlemen, please do not discuss the case among yourselves or with anyone else. Please do not permit anyone to discuss the case.
is considering dismissing based on these arguments, and the state would like an opportunity to file a written response. I don't know if any of the other defendants intend to do that as well, but given the high standard that we have on a motion to dismiss, and the analysis that the court has to do, I'm not sure it's necessary, but I defer to the court, otherwise we'd want an opportunity to file a written response. And from our perspective, we could probably get that done by Friday, if the court wants us to do that. We can argue it on Monday, but I would suggest we just go forward with defense giving opening statement as the court had already planned, and we can take up the issue of their slides. But otherwise, that's kind of where we are from the state's perspective.
Susan, did you get a email on that other issue we talked about? Okay. Mr. Arbenz, how long are you likely to take in your opening?
I don't believe I'll be longer than an hour. Probably closer to 30, 45 minutes.
So if you started now, you'd be done by noon? So what I'm thinking about doing is allowing the state to rest. Mr. Arbenz can do his opening statement, and then we can take up the issue of the motion to dismiss. I realize there is an issue sometimes about whether or not there's a waiver of it if you proceed into the trial beyond the deal, but I'm understanding that the court will recognize that there's no waiver here. Okay?
My only concern is if, presenting the case based on the charges that's filed, if involved, somehow it's different, I mean, that is a disadvantage.
I'm sorry, I'm having a hard time hearing you. Devolved.
I'm ready to go, Your Honor, but I would prefer we have the ruling before, because I could tailor my opening, which I did reserve, in part because I thought there was a possibility that the state's case might be different for the defense case, and I'd like to be able to, tell it the way it's going to be rather than say a bunch of stuff and then have it be totally different.
Of course, the building is closed on Friday, so we can't do anything on Friday.
Oh, okay. I didn't realize that.
It's a national holiday, but it's also Washington State Admissions Day. In addition to being Armistice Day, it's November 10th, but that's when it's celebrated, but it's November 11th. 1889 was when Washington became a state, and it's been Washington State Admissions Day. And then World War I ended on November 11th, probably in some kind of honoring of the state of Washington entering the Union, some 30 or so years later. And so it became Armistice Day 2. But it's observed on Friday, and so the buildings are closed, and it's a national holiday. I'm not even sure you can get mail on Friday. Anyway, so Friday doesn't work. Well, here's what I'm thinking might be good. We could go ahead and let the state rest, and go ahead and excuse the jurors until Monday. And we can have this discussion about the motion to dismiss after they've departed. And Mr. Arbenz can wait till Monday to do his opening. I'm not sure what to say about this. I learned over the break that one of the jurors has expressed some concern about something, which I'm not yet prepared to share with counsel, but I think it might be useful to have this little break for that reason too. And then we can maybe talk to you about that as well. But we've asked the juror to put the concern in writing, so there's no issue about it, and send it like an email to Mrs. Winnie. I don't know whether or not the person's going to do that. As of, at least right now, they haven't, but then they've just been informed of that request. So then you will know precisely what the concern is. I don't know what precisely the concern is myself, but hopefully this email would elucidate us on that. And so it might be prudent under the circumstances and really not understanding what my concern might be to take this break till Monday just for that reason. And I guess I would ask Mrs. Winnie to encourage the juror to get that to us. Now, whether they may choose not to write it, it's possible. In which case, we may well share with you what little we do know, unless that situation somehow is rectified. But as I say, we just learned about it, so it hasn't, and it shouldn't have any effect on the proceedings at this time. Okay. So with that, let's have the jury back. We'll let the state rest. We'll then excuse the jury till Monday, and then we'll have our discussion about the motion.
We have a written motion as well. So we're printing that right now. We can hand up copies.
How could you possibly have improved on what Mr. Pertzer and Mr. Fricke have provided me?
I didn't even try, Judge. Well, it's a different angle, but I think it's an interesting one.
All right, well, if we need to take a little more time, we could wait till this afternoon. Anyway, try to encourage the juror, and other than that, you may want, I would say bring him out and then try to encourage the juror after that, okay? Okay, thanks.
Obviously, the state will still want to have time to read whatever is being filed by Mr. Rankin as well.
I get it. You're always such a help. important week, and given that we're in midday and given the arrangement of witnesses and so on, we're going to remain in session for a couple little housekeeping things we have to do. But otherwise, we're going to excuse you guys all till Monday, when we'd expect to hear, I believe, then the opening statement from Mr. Arbenz, who's reserved his opening statement, and then start hearing witnesses from the defense. So back on Monday at your usual time, but otherwise, hold a second. You stay rested, yeah. Yeah. So with that, keep in mind our previous admonition, of course, that as we always do, to not discuss a case with each other or with anybody else. Do not permit anyone to discuss a case in your presence, and please avoid any media or other reports on the social media or the news media or otherwise about the subject of this trial. I hope you guys have a great time off. I was pointing out to council that not only is it Armistice Day that acknowledged or observed on Friday, it is also, I suppose, indirectly observed Washington Admissions Day. On November 11th, 1889, Washington became a state. Got the date right here on our seal, and or at least the year. And so think of something nice about the state of Washington on Friday, too. Other than that, you'll be recessed. Thank you. And council should stick around. Okay, you can all be seated. Let's give Mrs. Winnie a couple of minutes because she does have to talk to one of the jurors. Susan?
Are we certainly be on the record? I have a juror who left his lunch on the chair. I don't know if that juror's gonna come back, so I mean, leave. One other question, are we gonna be in session in the afternoon?
I don't know, it depends how long we take, maybe. Why?
Okay, well, we just need to make sure that if we're not in session in the afternoon, that we don't have a court reporter.
All right, we'll get there.
You gonna let Kim know?
Kim, is it Kim in this afternoon?
I think Kim's
No,
gonna be
here
here.
it says Kim or Kelly.
Okay,
Okay.
Kim was supposed to be here, so I
Alright.
need to know before lunchtime.
All right, well, we may need them for at least sometime this afternoon. Okay, so we're ready to resume on the record. There's been a motion received by, for a motion dismissed. The state wants more time to respond to these materials. I think we can proceed now. So, Mr. Fricke or Mr. Pertzer, you made the first motion here for Mr. Burbank?
Yes, there you go. Your Honor, may it please the court. Your Honor, the court's had the benefit, as we all have, and to hear the various witnesses testify. And the state is charged for Officer Burbank with a second-degree murder by felony murder, as well as first-degree manslaughter. And the components of the felony murder are unlawful imprisonment and also second, third-degree assault. Judge, respectfully, considering the evidence, we would urge that there simply is insufficient evidence to find that Officer Burbank committed the unlawful imprisonment or the first, second, or third-degree assault. There simply isn't evidence to support that when you consider both the evidence and the lack of evidence, and specifically talking about the lay or civilian witnesses who testified before the court, as well as the statements of the police officers. With respect to the lay witnesses, we have Sarah McGowl, Mr. Gowden, and Ms. White, which are kind of the triumvirate of witnesses that testified on behalf of the state. But what's significant is that when you consider Ms. White, her, Ms. Malang, her testimony, and then put that in conjunction with Ms. McGow's, Ms. White heard events going on 30 to 60 seconds before Ms. McGowl comes in the picture. And interestingly, although she did not see what was occurring, she heard the interactions of at least two men. We know from the testimony of Officers Collins and Burbank that they were the individuals that were interacting with Mr. Ellis, the side of the car and the front of the car. And Ms. McDowell and Mr. Lowry and Mr. Cowden saw the events occurred after it had already transpired. And so from that standpoint, there really isn't any evidence that there was any felony committed by Officer Burbank at all on Mr. Ellis. But there clearly is no second or third degree assault based on any type of testimony that we hear from the witnesses. And in order to put that into perspective, you need to consider the testimony of the doctors. All four experts that the state called, Dr. W., Dr. Mitchell, Dr. Veal, and Dr. Clark, were asked a variety of questions regarding the use of the taser, which is theoretically could be an implement that could have been used for purposes of the assault counts. But none of them stated that in and of itself was the cause of Mr. Ellis' death. They said that by being hit with the taser, it might increase his need for oxygen, might increase his heart rate, but that in and of itself did not kill him. And there's no testimony to suggest otherwise. And so that kind of gets us into the next stage. Well, what is the proximate cause of Mr. Ellis' death? Simply stated, none of the experts state by the time that Officer Burbank was no longer in contact with Mr. Ellis that there was anything that he did or didn't do that caused Mr. Ellis' death. He was after Mr. Ellis was handcuffed and hogtied, and Officer Burbank was one of several officers that was in the process of hogtying when there was other officers that were on Mr. Ellis. He left. He was there at the scene regarding that interaction for maybe 3 minutes. Medical didn't arrive for at least 10 minutes later, and there was an intervening causes by other officers that Mr. Burbank had absolutely no control of. Frankly, he had no control of the scene when Sergeant Lim arrived. And in these types of motions, construing the evidence in the light most favorable to the state, there is no evidence or combination of evidence that could support a finding that anything that Officer Burbank did or didn't do approximately caused Mr. Ellis' death. And the most clarifying testimony is that from from Dr. Clark when he says that, you charge this case. I'm gonna have a tough time getting beyond the 51% threshold that I have in labeling this case a homicide for purposes of my death investigation. He simply stated it's not there. And you don't have any additional evidence from any of the other experts. Specifically, I asked Dr. Mitchell and Dr. Duffy if they could pinpoint the time period in which this hypoxia occurred. None of them could do so. They simply cannot do it. Dr. Clark states that the most important factor for him is the spitting. And Dr. Mitchell states, yeah, that was the thing that caused him to aspirate, these food particles, which probably put him over the edge. That was way down the line from where Officer Burdick was. He had nothing to do with the spit sock. After the hobble was there, he was basically without seeing, talking to Sergeant Lynch. So based upon the evidence, the lack of evidence, and frankly, the finding of proximate cause, the state simply has not established it. It doesn't matter how you look at the evidence. None of their experts have stated that, Mr. Officer Burdick approximately caused the death of Mr. Ellis. They simply didn't say that, and they simply couldn't say that, because respectfully, he didn't do it. He arrested him. After he was arrested and hobbled, he was out of the picture, and at that point in time, he is no longer involved with anything that happened to Mr. Ellis from that point forward. So respectfully, Judge, in your great discretion, urge the court to grant the motion to dismiss both the second murder charge for two reasons. One is the lack of proof of a felony. That's the first thing. And if you don't have a felony, you can't have a felony murder. And secondly, and probably more importantly, for not only the secondary murder, but also the manslaughter charge, there's nothing, he wasn't aware of any type of a risk that he recklessly ignored. And so under those circumstances, we urge Your Honor to dismiss both counts related to Officer Burdick.
Okay, thank you. Mr. Oster, are you going to make this motion?
Yeah, thank you, Judge. First, let's start with the standard. I know the court's aware standard is that the court has the authority to dismiss if, in the light most favorable to the state, there's insufficient evidence that any reasonable jury could find guilt beyond a reasonable doubt. And that's the standard. As it relates to count one, the state has chosen to charge my client with felony murder predicated on Mr. Ellis dying in the course or furtherance of assault in the second degree, assault in the third degree, and or unlawful imprisonment. And as the court's aware, under WIPIC 2703, those acts must be unlawful as a matter of law, an element that must be proven in order for the predicate felony to withstand scrutiny and go to the jury.
You mean unlawful force?
Well, no. The definition of an assault under 3550 is that it's unlawful.
In other words, it's done without lawful force.
Correct, without lawful force,
Right.
specifically for the underlying predicate felony for each of the three charges. Sorry, I'll slow down for the court reporter. For each of the three charges here. That thereby creates an element through which the state must prove unlawfulness in order for that to withstand. Now, not only do they have to disprove that there was no legal authority for the act, they must also establish that any act my client committed in the course or furtherance of the predicate felony was the proximate cause of Mr. Ellis's death. WIPIC 2502 tells the court, I'll read it, there's a causal connection between the defendant's conduct and the death such that the defendant's act was the proximate cause of death. That is defined as a direct sequence unbroken by any new independent cause without which death would not have occurred. And so the state fails on a couple of grounds, at least as far as the evidence, right? I think the court touched on it 2 or 3 days ago when having a conversation with Ms. Nicolavo. What is the unlawful? How is this unlawful? You've presented no evidence about the initial contact that would prove that the act by Officer Collins was not lawful. State's response, well, Ms. McDowell says she saw the whole thing, and the court, I think, appropriately said, well, that's completely inconsistent with Ms. Mailing White's account. And I like Mr. Percher, but again, they keep getting the time frame wrong. The actual evidence...
I disagree with your time.
Well, they're wrong. Because the testimony of Miss Malang was, I was laying in bed, I had just about dozed off, I heard a commotion, for 30 to 60 seconds before I decided to sit up and look out the window. I then stood up, got on my knees and looked out the window for 45 to 60 seconds and watched an altercation at the front driver-passenger headlight, wherein she didn't know it was Mr. Ellis, but Mr. Ellis is flailing, appeared to her to get away from the officer, and there was a physical altercation. She then goes down to her fiance, now husband, and attempts to wake him up. Says, while I'm attempting to wake him up for about 15 seconds, I hear Sarah McDowell's voice. So it's not 30 to 60 seconds. It's 1.5 minutes to 2 minutes and 15 seconds of interaction that occurred before McDowell even knows what's going on. How else do we know that? McDowell said that he had nothing in his hands the entire time I saw him. Seth Cowden, I had nothing in his hands when I saw him. Keon Lowry, he had nothing in his hands the minute I saw him. We know that's not how this started. We know it's not. I mean, Mr. Lou stood up in opening and held up a box of donuts and a bottle of water to suggest that the EBT card from Mr. Ellis showed that at 11:11 p.m., just before this, he purchased those items. He was walking down the street with those items. And we know he was because the box of donuts is at the passenger side window with corresponding powdered sugar on the window where he struck the vehicle 3 times. Oh, and by the way, he has a laceration on his left hand, left knuckle, consistent with blunt force trauma, consistent with the strike marks. So we know they didn't see what started this. The court said as much 2 days ago. And so the question becomes, is there evidence sufficient for a reasonable juror to find guilt beyond a reasonable doubt in that circumstance? And the answer is no. It's just not. They still, even if the court disagrees with that, they still have to establish that my client's acts were the proximate cause of the death. As far as I can tell, the assault 2 alleged is an attempted application of an LVNR that the jury has seen on video, which was never actually applied. But more importantly, and most importantly, even if it was, Mr. Ellis is alive. As soon as he recovers from the first taser application, continues to fight. That would have been the end of, in the course or furtherance of, an assault 2. He did not die in the course or furtherance of that. That's a completed offense at the time the attempt is done. And Dr. Veal, Dr. Clark, Dr. Mitchell, and Dr. W. all said that had no impact on the cause of death in this case. So we know there's not a proximate cause basis for assault 2. Is there a proximate cause basis for assault 3? I'm not even sure what the assault 3 is. I don't think they know what the assault 3 is. That's negligently inflicting bodily harm. How can Mr. Ellis die in the course or furtherance of bodily harm without anybody suggesting some sort of harm caused the death in that manner? There is none. Well, is it unlawful imprisonment? What evidence do we have that it's unlawful? Again, none. And did he die in the course or furtherance of that? If that's their theory of the case, he's secured and my client is out of the picture and he's still alive. And that there's some cause after that that caused the death. Dr. Veal said it. I asked him directly 3 times. Is there any act that Officer Collins did at any point that could account for the positional asphyxia or cause the death? No. That's the evidence in this case. They have no evidence that anything that occurred before my client was relieved from Mr. Ellis had any impact on the cause of death. And so that's, again, a completed act, he's alive, and no proximate cause. The same analysis goes for recklessness, and I said this in my Nabstad motion. The only theory through which my client can be held accountable for the conduct of another is if he's acting as an accomplice too. Meaning, is he in agreement, facilitating, encouraging the commission of an act, and that act was reasonably foreseeable post my client's conduct? By definition, it's not. They've charged Officer Rankin with reckless conduct. How can my client foresee reckless conduct occurring in the course or furtherance or be an accomplice to reckless conduct? He can't. So again, the court has to make a determination. What evidence did the state produce that those 12 jurors can find beyond a reasonable doubt was reckless by my client that caused the death? The state turned this into a violation of police policy case that maybe my client's elbow strikes were excessive force. That didn't cause the death. Maybe my client's attempted LVNR was an excessive use of force. That didn't cause the death. Then they turned it into it's a duty, Judge. My client has a duty to render aid or make sure that Mr. Ellis is safe. And I guess the theory is that failure of that duty is the proximate cause of the death. Well, the problem for the state in that respect is Lieutenant Wilson was advised by my client upon arrival that Mr. Ellis was in medical distress and to get to him immediately. Lieutenant Wilson said, wouldn't have changed anything. I went there immediately, I performed my duties immediately, and nothing would have changed the outcome in his opinion. The state, I think, suggested during the Knapstad motion that apparently my client heard Mr. Ellis say, I can't breathe, and he failed to relay that information to other officers, thereby breaching a duty of care to Mr. Ellis. Well, the problem with that analysis, Judge, is Officer Rankin and Officer Ford hear him say, I can't breathe. In fact, they talk about calm down. If you're talking, then you can breathe. And that's who, along with Sergeant Lim, my client turns custody and care over to. So he's supposed to tell them that he said he couldn't breathe when they heard him say he couldn't breathe? And even if that was the case, how is failure to do that the proximate cause of a reckless conduct that caused the death? It's not. The state's failed to produce any evidence that implicates my client committing any act that caused the death of Mr. Ellis. And so the court has to dismiss. Thank you.
Mr. Conrad, I take it?
So I think our case is a bit different than our co-defendants. And I think the most important aspect of that is the fact that there is no independent witness in this case that corroborates anything incriminating regarding our client. The state's case has been solely focused on our client's statement, and our client's statement only. I'll say at the outset, I was thinking about corpus delicti within this case, because I was...
That's what you're indicating in your motion here.
Exactly. And so, you know, I find it a bit puzzling, right, that the state, the prosecutor in this case, who's a quasi-judicial official, who shouldn't just be seeking conviction, but instead presenting all the evidence to a jury to allow a jury to make a determination, has 13 eyewitnesses in this case and hasn't produced a single one of them. 13 officers, they haven't produced a single one of them. And instead, the only thing that they've produced against our client is his statement. That's it. And when you look at the other statements that have come in that have anything to do with our client, and I tried to make that point clear, the only statement that came in was Lieutenant Wilson came to the scene. He asked for hobbles to be removed. The hobbles to be removed. He said that took 5 seconds and it did not delay any care. That's the only corroborating statement that has anything to do with our client. All the expert testimony relies solely on the statement of our client as well. I think the court knows that the idea behind corpus delicti is that you can't just use an individual statement. There has to be independent evidence associated with it. And the state had the opportunity to present that through differing officers and differing independent witnesses, but they chose not to do that. The only independent witnesses that they called to the stand had nothing to do with Officer Rankin. And that's Miss McDowell, Mr. Lowry, Seth Coden, and then you have Miss Malang, formerly Miss White. And each one of those individuals never saw our officer on scene do anything other than just arrive. And that surely is not independent evidence of a crime being committed. And there's a case, Pineda, and it's 99 Washington Ave at 65. And in the Pineda case, it's a case involving the death of a baby. And they charged the mother with manslaughter in that case as well. And the state argued there to the trial court, which dismissed on corpus delicti. They said that the doctor that they had presented had an opinion that the cause of death of Amber, the child that died, was asphyxia as a result of suffocation or smothering. And the court goes on to say, as already seen, the corpus delicti rule must be met by evidence independent of the defendant's statement. An expert opinion based solely on the defendant's statement is not independent evidence of those statements. Because Dr. and it's Lacina, because of Dr. Lexina opinion was based wholly on Kelly's statement, it cannot be used to satisfy the corpus delicti rule. And the trial court acted properly by not considering it. In there you had a case that's very similar to this case, where there was no anatomical finding of death. And so the experts opined, based on the statement of the mother there, that that was the cause of death, asphyxia or suffocation. Here the experts have done the exact same thing. It all hinges back on Officer Rankin's statement, and no other evidence has been presented. I mean, I can't think of any. I don't know if the court can think of anything else, but that's it. And so when you look at the standard that the state needs to meet, not only under Green but under Corpus, they haven't met that. They haven't shown anything that shows recklessness. They haven't shown anything that shows proximate cause unrelated to Officer Rankin's statement. And I think when you combine Green and you combine the corpus delicti rule, this court really is forced to dismiss this case at this point, because that is the only evidence that the state chose to present to the court. I think another quote is from Etienne. It's E-T, or Etienne. It's E-T-E-N, which is 130 Washington 2nd, 640. It's a 1996 case. And there the court says that circumstantial evidence proving corpus delicti must be consistent with guilt and inconsistent with the hypothesis of innocence. So again, this harkens back to what other evidence is there other than the client's statement. And I think even if you look at the expert testimony, the only thing they relied upon was that. And then apart from that, each one of them admitted that they don't know how long Officer Rankin was in certain positions, or Mr. Ellis was in certain positions, and what weight was applied. They haven't presented any independent evidence of that through any other eyewitnesses or officers that were on scene. They're solely relying upon our client's statement. So the last thing I'll point out is that our motion to dismiss is also specific to this accomplice liability theory. So the state has chosen to charge Officer Rankin as an accomplice. And, you know, I've seen that in criminal informations before, that they just include that typical language. And I wasn't sure exactly what the state's theory was as to how he was an accomplice or who he was an accomplice to. And then when I received the state's proposed jury instructions, they had taken the to convict instruction from the manslaughter first statute and modified it by including the word that it's the defendant's acts or accomplice, which then I said, well, they're not just charging. I mean, this isn't just a typical or something that's boilerplate in information. They're actually going under some accomplice theory that our client is an accomplice, because I've seen this jury instruction now. And so I've been wondering, an accomplice to who? Right? Because, again, there's only our client's statement.
I think the better question is an accomplice to what?
And to what?
But go ahead.
Sure. Well, yeah, I agree. So that's probably a better question. I mean, I think you have to overcome the first hurdle under the theory of manslaughter. Absent Officer Rankin's statement, what evidence do they have of that? And then apart from that, an accomplice to what or who? Because, again, absent Officer Rankin's statement, what have been the statements that have been admitted against him? And, I mean, typically you see, so let me stick with this. So the accomplice theory, right, has to be knowledge that he is participating in some crime and what that crime is. I mean, the testimony has been only from Officer Rankin's statement, and even their own expert acknowledges that there was nothing inappropriate about him responding to the scene and being on scene. I mean, there's nothing that would implicate knowledge from him that he would be participating in any sort of crime. I know the state has chosen to try and accuse Officer Burbank and Officer Collins of just accosting Mr. Ellis while he's walking down the street enjoying nature, but the truth of the matter is that Officer Rankin, regardless of whether that theory is accurate or not, and I won't get into that, but regardless of that, there's nothing that would implicate that Officer Rankin would have any idea of any of that information prior to arrival. And he can't be an accomplice to Officer Franis, and he can't be an accomplice to Officer Ford, and he can't be an accomplice to Sergeant Lim. None of those individuals are charged. So the only person he could be an accomplice to would be these two gentlemen, and for what? And how? And then on top of that, you have the corpus delicti issue, which is, okay, you take Officer Rankin's statement away, and then what do you have? I mean, it's a huge problem for the state. I'm shocked again that they're not calling 13 eyewitnesses. And had I known that, we would have objected at the forefront to our client's statement coming in at all. Because typically, and that doesn't waive it, because it's come in, because I can't anticipate that that's what they're going to do when they list 80 witnesses. But typically, I'd bring this motion from the forefront and say, aside from our client's statement, there is no independent evidence. And before you start admitting our client's statement, you produce that evidence. I was expecting them to do that. They didn't do it. And so now we're at the juncture where they've now admitted our client's statement, but they haven't presented any independent evidence. So if the court's not going to dismiss outright or the accomplice theory liability, then I would ask for an instruction that the statements that are uncorroborated by Officer Rankin are redacted or removed from the record because there hasn't been any independent record of it or evidence of it. And I think that that's the appropriate resolution in this case then. So unless the court has any questions.
No.
Thank you.
State's response.
You want me to start?
Well, I'll tell you what, if you want, we can start at 1:30.
Sure, if the court wants to do that, or that's fine.
Well, I realize you did get some of these things on reasonably short notice, although much of this was not unexpected.
Yeah.
And much of this we already saw in the Napstead motion.
But it might take me more than 4 minutes to respond.
Well, I don't mind going a little long if we could get that done, but I think I'm willing to let you have some additional, right? So we'll be at break until 1:30. Thank you, everybody.